Lori Vallow has filed a motion for a new trial, and we're going to go through this together. I have skimmed just a little bit, and it is focusing on jury talking to the media, but also it's focusing on the prosecution, according to them, lying to those jurors. Let's get into it. Lori Daybell requests that the court grant her a new trial. This motion is filed pursuant to the protections provided by Rule 24.1 of the Arizona Rules of Criminal Procedure, the Fifth Amendment Due Process Clause of the United States Constitution, and Article 2, 424, Arizona State Constitution. This motion is accompanied by the following Memorandum of Points and Authorities. Memorandum of Points and Authorities. Facts. Juror misconduct. If you follow this trial on my channel, I was so worried about this jury. On April 28, 2025, it came to the attention of this defendant's advisory counsel and later the court that Juror 15 made a statement indicating he had knowledge of this defendant's prior conviction. Exhibit 1, clip Fox 10 News. He also indicated that he was leaning towards a not guilty vote up until yesterday and through deliberations. Exhibit 1, minute 055. This prior conviction involved the homicide of her children in Idaho in 2013. This defendant did not testify in this trial, and this conviction was not presented by the state as Rule 404B Other Act evidence. Thus, Juror 15 should not have learned about this information. Because this case was a high-profile matter, once the jury was released from its admonition, jurors were free to speak with media. During an interview, Juror 15 was asked about his reaction upon learning about this defendant's prior convictions. He stated the following: "You know, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell." Exhibit 1, 312. And then we have the preclusion of Tylee Ryan and Alex Cox statements and impermissible expert testimony by Detective Daniel Coons. Prior to trial, the court precluded this defendant from presenting to the jury any of Tylee Ryan or Alex Cox's statement. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay as they show effect on listener pursuant to Arizona Rules of Evidence 8033. The state filed a motion in limine throwing a blanket hearsay objection over the entire statements. The court indicated in a pretrial ruling that it would, at least to Alex Cox's statement, take it on a statement-by-statement basis. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler police detectives during that walkthrough. Now, Lori was allowed to mention he did a walkthrough because we heard about the walkthrough, but I remember his statements, I believe, she wasn't allowed to ask about, and there wasn't body cam during that walkthrough too, which was a big mistake from the police. Let's keep going. Then, in the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. This defendant objected to his testimony as an expert witness based on lack of foundation and her not having had time to rebuff his professional opinion. Again, this defendant was precluded from discussing Alex Cox, the shooter. Walkthrough that was conducted with several Chandler police detectives, including Detective Coons. This walkthrough was precluded as inadmissible hearsay. However, it formed the basis for Detective Coons' questioning with the medical examiner and how he then investigated this case, as Alex Cox indicated he shot the victim in self-defense. Discovery violation. On April 12, 2015, during trial, Ms. Trina Kay produced a hard drive containing the gray key information for Charles Vallow's cell phone. The contents of the hard drive are exculpatory evidence. Defense had been requesting this evidence so that she could provide it to her independent expert for his review. This discovery disclosure occurred in the middle of trial. Now, I'm trying to remember exactly here. I remember Lori requesting data and then claiming she couldn't open it because she didn't have the software wasn't opening it, and that was a whole thing. But I don't remember her bringing up a discovery violation during that part. It was more that her expert couldn't open it. I actually don't know the exact timing of how this would be, if this was a discovery violation or not. I can't remember, if I'm being honest. I remember it sounded like they didn't have the software to open it, but that wasn't the prosecution's fault, because the prosecution said they'd already given her the readable format prior, if I'm remembering right. Prosecutorial misconduct. On April 8, 2025, State elicited irrelevant, prejudicial, and improper character evidence when she asked Chandler Fire Captain Keller if he overheard any conversations with this defendant. Miss Trina K asked Captain Keller on direct examination, "Did you overhear this defendant talking with police?" He responded in the affirmative, stating he overheard someone stating, "not getting invited to pool party because of the commotion at the house or something." All right. I remember people talking about this pool party statement, like wondering if it would make it in, like before the trial was happening. So that's interesting. Caught the defendant off guard as Captain Keller indicated during his interviews with Chandler Police just after this incident occurred that he only saw the male outside on the curb and did not mention even seeing this defendant. I mean, I would argue you can hear someone without seeing them. And if you're at a murder scene and someone's acting chipper, as Lori was, that's my wording I would use, I might key in on that sound. During closing arguments while addressing the justification defenses, Ms. Trina K told the jury that this defendant was not entitled to any of these self-defense instructions. Ms. Trina K also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. Ms. Trina K knew from previous testimony, interviews, pretrial defense interviews that Summer had begged Alex to go over to this defendant's home because of Summer's concerns for this defendant's safety. Why didn't you bring that up, Lori? Oh, wait, you didn't call Summer. Finally, Miss Trina K commented several times on this defendant's demeanor during this incident, drive to the police station on the body camera, and told the jury, "You did not see her cry in that interview," yet knowing there were portions of the defendant's interview that had been cut from the full interview admitted by the state where she sat in the room and did show emotion and can be seen grabbing a Kleenex. Okay. So the question is, the jury said they watched the full interview, right? Was her grabbing a Kleenex cut? I don't see why they would cut it. And if it wasn't cut, because it wouldn't have been hearsay, that'd be available, right? Court's lack of impartiality. The court precluded this defendant from presenting a defense by striking her witnesses, including but not limited to Nate Eaton, who, remember, Nate Eaton is not a witness to the crime. Nate met Lori in Hawaii while they were on the run. And Brandon Boudreaux, which again, he wasn't there at the scene before they were even called to the stand. And Brandon, remember, he is a victim of Lori who's going to trial next. Specifically, before testimony began, the court required this defendant to establish on the record what relevancy her witness would present. And you didn't do it, Lori. You didn't do it. Your revenge tour was why you wanted them, and you couldn't convince the judge. This required the defendant to state in front of the prosecutor her defense strategy. This is not required under the law or any rule of evidence. Well, you could have maybe used that was prejudicial and shouldn't have happened, but Lori, you could have done it still. Like, you were being told, do this or they can't be witnesses. Like, it was very obvious she was just pulling anyone she wanted to go after up. And then, does any of it matter when she didn't call a defense? Lori didn't put on a defense. Can she argue she didn't put on? Is she going to argue she didn't put on a defense because she couldn't put Nate Eaton on the stand? Is she going to claim the reason she didn't have a defense is because Nate Eaton wasn't on that stand? During cross-examination of a civilian witness, Serena Sharp, in relation to testimony regarding religious beliefs, the court commented during the prosecutor's objection to relevancy, stating, "I guess to the extent that you are comparing yourself to these biblical figures, I will allow it. I remember that line. That's one that stuck out. Part of the state's case was to establish that this defendant had stepped outside of the Mormon religion by claiming she was a translated being, specifically in text messages saying she would be like Nephi, and that these messages were nothing more than part of a conspiracy to kill Charles Vallow. This defendant attempted to establish that being translated was a regular part of the Mormon religion, and thus a relevant line of questioning. Okay, but you did say you were going to be like Nephi. Is Nephi a biblical figure? Yes. If you say, I am like someone else, are you comparing yourself to them? Yes. So, factually, in the basis of it, Lori was comparing herself to biblical figures, right? That's what she was doing. You might say, well, the judge should have worded it differently, but the judge was also just using a factual basis. Lori is comparing herself to biblical figures right now. You can ask questions related to you comparing yourself to those biblical figures. The Arizona rules of criminal procedure provide that a court may grant a new trial when a juror or jurors have committed misconduct by receiving evidence not properly admitted during the trial. Additionally, a new trial is appropriate for any other reason not due to the defendant's own fault if the defendant has not received a fair and impartial trial. Oh, I'm sure I didn't forget this part. This defendant attempted to establish that being a translated being was a regular part of Mormon religion, and thus a relevant line of questioning. Okay, I did read that. I just want to make sure. Okay, so she's saying, because of the juror, again, people were saying that this juror was the same one who was on the phone with his daughter, and then they were trying to claim it was the same one that was talking to another juror about the case. But they say in this he's juror 15, and I don't believe that was juror 15. So as part of why I haven't covered some of the Lori Vallow update stuff and this juror stuff is because I didn't want to if one juror did something, I didn't want to accidentally say it was another juror. I was going to wait for court documents because they know which juror is which one. This one is 15, right? At least according to Lori, they're 15. The number, not the age. They're old. They're older. They also said, if I'm remembering right, this juror, just so everyone knows, this juror seemed confused to me in the interview I watched about how life insurance worked. He seemed to think that Lori had access to that $2 million. That's not how that works. His only source of news, according to him, was the national Fox News. He doesn't watch local stuff at all, so that's how he missed the case, I guess. He was honestly, you need to watch the interview. It's something else. This defendant is entitled to a new trial because the jury received and consulted extraneous evidence. Once a defendant shows the jury received and consulted extraneous information, prejudice must be presumed and a new trial must be granted unless the state proves beyond a reasonable doubt the information did not taint the verdict. In State v. Poland, the court held that since the federal convictions were based on the same series of acts as were the issue in the state prosecution, evidence of prior convictions is inherently prejudicial. And I want to be clear, she might actually get a new trial due to this, right? Normally when it's Sarah Boone, I literally don't think there's any way she's going to get anything out of it. The judge tried so hard to make sure she doesn't. This case, I haven't liked it. I didn't like the way it was handled. I didn't like the way the jurors were handled. I didn't like a lot of it. She could get a new trial, and I would not be shocked if the next jury is sequestered. When a juror does not base his verdict on evidence developed at trial, he violates the fundamental integrity of all that is embraced in the constitutional concept of trial by jury. Such misconduct by jury members denies criminal defendants their rights under the 6th and 14th Amendments to confront and cross-examine their accusers about this extrinsic evidence. This defendant's advisory counsel and the court both received evidence that the juror's verdict was tainted when Juror 15 spoke during his interview with Fox 10 News, disclosing that he had learned of her prior conviction seemingly 1 day prior to the admonishment being lifted. Because it is clear Juror 15 had information he was not entitled to know prior to conducting deliberations, the burden is on the state to prove beyond a reasonable doubt that this information did not taint the verdict. The state will not be able to meet this burden. This defendant is entitled to a new trial. Even if an offending juror may not have been influenced the other jurors, unanimity is required to convict a criminal defendant, and the juror's conclusion may have been different had the juror not consulted extraneous sources. This is also a juror that was on the side of Lori until the end. He talked about how he was confused that they were talking about Alex Cox. Like, again, it is a very, to me at least, upsetting interview with this juror. It's wild. In Cornell, a juror looked up definitions that were neither admitted into evidence nor included in the trial court's instructions. A juror testified he was confused and undecided about the allegations, and his reference to outside sources made the decision that the defendant was guilty. Reference to dictionary definitions by jurors is usually considered a harmless error. However, the appellate court found this was not a harmless error, and the defendant was entitled to a new trial. Similar to the juror in Cornell, Juror 15 stated he had information neither admitted into evidence nor included in the trial court's instructions. Even more egregious than in Cornell was his information learned that this defendant had prior homicide convictions. As in Poland, this information is inherently prejudicial, as these prior convictions directly related to this prosecution. At the time of writing this motion, it is not known if Juror 15 shared this information with other jurors. As far as I know, there's been no mention of it. However, what is clear is that Juror 15 did not follow the admonishment and notify the court of him having learned of this information, and so an inquiry should have conducted prior to deliberations. So, he kind of reworded it a little bit, and sounds like maybe he got things out of order, and he found out she was a killer after, and he was thinking about her the drive home the day before, but again, how do you prove that as the prosecutor when he says that he knew about it the day before? Like, he can say, I misspoke, but, I mean, these are serious charges, right? These actions directly violated the court's instruction that could have factored into Juror 15's verdict, if not multiple jurors' verdicts. In fact, Juror 15 knew that up until the day of closing arguments, he would have voted not guilty. Given the statement is unable to prove that Juror 15's misconduct did not taint his and potentially other jurors' verdicts, the state will not be able to overcome the overwhelming evidence of Juror 15's misconduct in order to prove beyond a reasonable doubt that Juror 15's misconduct did not taint the jury. Accordingly, this defendant is entitled to a new trial. I'm going to be honest, I haven't seen the state's response. If there is a response, I don't think it's out yet. I would not be shocked if she gets a new trial. I wouldn't. At this point, I wouldn't. I hate it. Now, obviously, if she has a new trial and it's allowed to be broadcasted again, or even if it isn't, and I do updates, like, it's money, right? Like it gets views and it gets subscribers, but it sucks when you know the verdict was right, but it might have to happen again. The families might have to go through it again. Like, imagine you have the closure, at least when it comes to Charles, right? And then this happens. Like, imagine you're reading this as a member of Charles' family. All right, here we go. Preclusion of Tylee Ryan and Alex Cox statements, and because the court allowed expert testimony without a Rule 702 ruling, this defendant is entitled to a new trial. So we have a whole new reason now. New trial is appropriate if, for any reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. By precluding Tylee Ryan and Alex Cox's statement, this defendant was prevented from presenting part of her defense at trial, and thus she did not receive a fair and impartial trial. The court made a pretrial ruling that, at least to Alex Cox's statements, it would be a statement-by-statement ruling. Instead, this defendant was even precluded from discussing Alex Cox's statements during his walkthrough. These walkthrough statements form the basis for Detective Coons being able to testify as an expert, yet she was precluded from cross-examining him on this foundation. For this basis, the defendant is entitled to a new trial. I mean, the thing is, it was statement by statement basis, and she can name one basis, right? Like, it's not like she put on a defense and she kept getting stonewalled about Alex. In her own document here, she names one instance. You can't say, I tried once and they told me no, so they were always going to say no, which wasn't allowed. You didn't try multiple times, right? At least if you're going off of this document. Discovery violation that occurred in the middle of trial entitles the defendant to a new trial. Okay. I'm trying to not cough. Maybe this is going to explain the whole phone thing where I was a little confused because I don't remember it exactly. But remember, this is Lori's version. Discovery rules are designed to implement and not impede the fair and speedy trial rights. On April 14th, during trial, Ms. Trina K produced a hard drive containing the gray key information for Charles Vallow's cell phone. The contents of the hard drive are exculpatory evidence. The defense has been requesting this evidence so she can provide it to her independent. Now, the thing is, again, if I'm remembering right, the state had literally turned over all of the data in a readable format. Sarah was then claiming that it wasn't all the information. But I don't think she made that claim until trial. Not Sarah, Lori, jeez. I don't think she made that claim until the trial happened. And if that's the case, if she didn't make that statement until the trial happened, that's on her. But also, they gave her this just basically, in my opinion, to shut her up, right? Like, she couldn't even open it. So, she got a different version, basically a copy of the information that she herself can't open because she demanded it mid-trial and is now saying it being given to her mid-trial is a violation. This part is nonsense, in my opinion, so far. The state's discovery violation is one, the importance of the evidence which the defendant was deprived cross-examination, the right to confrontation and proper investigation examination for the defense. The state manifested the surprise and prejudice to the opposing party. The violation was motivated by bad faith, which neither the court nor the state corrected. Many other relevant factors that the state saw fit to depriving the defendant of her constitutional statutory rights. Acts of prosecutorial misconduct entitles this defendant to a new trial. Okay. A new trial is appropriate if, for any other reason not to defendant's own fault, the defendant has not received a fair and impartial trial. This includes prosecutorial misconduct. The statements elicited from Captain Keller were irrelevant and prejudicial to this defendant, yet Ms. Trina purposefully asked this witness if he overheard any statements. Did Lori even object to this? I don't think so. Second, it is improper for a prosecutor to misstate the law or evidence during closing arguments. Ms. Trina K stated the defendant was not entitled to self-defense instructions, yet they were clearly provided to the jury. I don't think she said you weren't entitled. I might be wrong. Because I have to assume, if this was done by an actual lawyer, I would have to assume that they have re-listened to it, right? I think Trina K said something along the lines of that it wasn't self-defense, that it was like she went through the instructions and it wasn't these things. Like, not that she wasn't entitled, like she was entitled to the instructions being read, but the state can say that the facts don't match, right? Like, Ms. Trina K also gave false statements in her closing argument by stating Alex had no reason to be at this defendant's home and this defendant told him to bring a gun and extra ammo. Ms. Trina K knew from previous testimony, interviews, and pretrial defense. Why didn't you object, Lori? That Summer had begged Alex to go over to this defendant's home because of Summer's concerns for his defendant's safety. Lastly, commenting on this defendant's demeanor, specifically stating this defendant did not cry during her police interview, was improper comment as she had cut this portion of the exhibit entitled, admitted that she called a full interview. So Lori is saying it was cut. And there is timestamps. Okay. Interesting. I mean, the thing is, we can't know if it was cut because we don't have the juror cut, right? We only have raw. We have it raw. Judge commenting on the evidence during the defendant's cross-examination showed a lack of impartiality and entitles this defendant to a new trial. A defendant may move for a new trial based on the court's lack of impartiality. Under the law, a trial court is presumed to be impartial and free from bias. The defendant can rebut this by the preponderance of the evidence by showing the court required her to present her defense strategy to the state before calling any witnesses. You weren't explaining how any witnesses were relevant, Lori. You were calling literal victims. You were calling media who wasn't present at the scene. The state could explain how every one of their witnesses were needed. You couldn't explain any of them. That at least you wanted, that we argued about. I'm sure you could explain Summer and things like that, but you didn't call them. You didn't even put on a defense. Rule 15.2b of the Arizona Rule of Criminal Procedure requires the defendant to disclose for each listed defense other than the defendant that the defendant intends to call as a witness at trial in support of the defense. Rule 15.2c1 requires the defendant to list the name and address of each person other than the defendant intends to call as a witness in any written or recorded statements of the witness. There is nothing in Rule 15.2 that requires this defendant to present her defense strategy in order to call a witness. The thing is, there were filings in court for at least Nate Eaton that he had nothing to present. These were filings, right? And the judge agreed. And they weren't even precluded, if I remember right. Nate Eaton wasn't even fully precluded. It was, if I'm remembering right, they were allowed to be at the trial, and I could be misremembering, but the judge specifically stated there was a possibility they could still be brought in, right? Like, she would have to prove that they were needed, and they would be valid witnesses, but I believe that was the answer. One, she's bringing up two people. One is a reporter who had nothing to do with the case and was there way later interviewing her in a parking lot. Number two is a victim who was not there to give firsthand information. Another one of her victims, right? She's not mentioning that, obviously. But I'm sure the state's response will. The Fifth Amendment of the United States Constitution provides this defendant the right to subpoena power. This preclusion of a witness and requirement of this defendant to inform the state of her defense prior to calling any properly noticed witnesses shows a specific claim of partiality. No, it wasn't all your witnesses. They didn't argue about some of them. Some of them you just didn't serve. And then some of them that you did serve, they had to be released by the judge because you didn't put on a defense. I mean, obviously, I understand. I understand that you're going for a new trial. You're going to throw everything at the wall, right? And whatever. Like, it doesn't make the juror stuff less powerful. But come on. Second, for the reason established that the court commented while responding to the state's relevant objection that the comment showed a specific claim of partiality by casting doubt on this defendant's credibility on this religious issue and in general showing she cannot be trusted. The court commenting to a relevancy objection, I guess to the extent that you are comparing yourself to these biblical figures, I will allow it. That was explaining to you what you can do, right? Like, there was an objection, and the objection is not going to cover the part specific to what you were comparing yourself to these biblical figures. At least that's how I understood it. Be seen as injecting his own opinion as to this defendant's reliability during her cross-examination. This comment is even more important when taken into consideration that Juror 15 in the Fox News 10 clip indicated he ultimately made a decision to vote guilty based on two text messages, including the one describing, I will be like Nephi. Lori, that is you comparing yourself to a biblical figure. That's what words mean. The court inserted his own improper comment when a simple overruled or sustained was warranted. It wasn't, though, right? Like, he wasn't giving her the ability to grill these people about all of the Mormon religion. She was being told, you are allowed to talk about it, to question them, specifically what is relevant to this case, which would be you comparing yourself to the biblical figure. You couldn't ask them about unrelated Mormon topics, okay? This, in and of itself, shows a lack of impartiality and requires a new trial. Conclusion, given the above reasons, this defendant respectfully requests the court grant her motion for a new trial. So with all that said and done, what is my thoughts? What do I think this is going to happen? I want you to be prepared, in my opinion, as a layperson. I just want you to be prepared that she gets a new trial for Charles Vallow. I think Juror 15 might do it for her. I think everything else is nonsense. I really do. Every other point she brought up, Juror 15 might get her a new trial. Wonder if he'll still want to do interviews. And if you don't agree, I recommend you watch the clips of him. I really do. About thinking about her serving 3 life sentences the day before, and just not even related to this, like the mindset of that juror in the Fox 10 interview. The mindset, I can't remember who else interviewed him. He has like a half-hour interview. There might be some bias. I don't like the guy's attitude, and I don't like the way he thinks. I don't think he understood what was going on in part of the trial. I'm going to be very honest. I don't think he understood what was going on. I don't know if he wasn't paying attention or if he couldn't comprehend it. He seemed confused about very basic ideas even now that happened in the trial. I watched his interview, like the longer one, and I literally got mad about it. I had like notes, and I like made a whole video going like down through what he said and my thoughts, and like I ended up recording it and then not posting it because I'm like, it's too mean. Because maybe he's a bad like interviewee, right? Maybe he isn't what he comes across as, right? But he might cause a new trial. I think it's a possibility. And I think that I think the families and the victims should be prepared for that. I don't know how that works because the next trial, they're wanting to use things from this trial in it, possibly. So if she gets a new trial, do we then delay the Brandon trial? Because the reason Tylee and JJ didn't come into this is because they were after the fact, right? So if you delay the Brandon trial and do the second Charles trial, maybe on the same days, like, I don't know how, like, maybe they could swap it in. I don't know how easy that would be. I would assume I'm going to assume they could do it. And then just have to do another trial day for Brandon, because we haven't even gotten to the point of like the witnesses and stuff for the Brandon stuff. They don't have their next trial date to even discuss setting up for this trial till like May 14th. So if she gets a new trial, they might want to do the new Charles trial before the Brandon trial, just so they can bring in the verdict from the Charles trial. Because I have no doubt she's going to be found guilty. Okay? I don't think the state has any doubt she'll be found guilty if there's a new trial. But just because would be found guilty in a new trial doesn't mean she won't get one. Maybe the state doesn't think they need it. They can go ahead and do the Brandon trial. I don't know what would be better for the families. Maybe just, I mean, if you were the family of Charles, I would assume I would want a new trial as soon as possible to get it over with so I can, move on instead of having to go through the Brandon trial and then the Charles trial. It's a headache, it's a mess, and I think if she gets a new trial, we can put the reasoning probably on Juror 15. That seems the most egregious, right? I'll be watching, I'll be checking. I'm sure the state's response is going to be that he misspoke. But is that enough? I have my doubts. I haven't really looked into like lawyer. I don't know if any lawyer channels have talked about him making the statement and what the outcome of that could be. Maybe it's nothing. To me, it just feels like I feel like she's going to get a new trial. But that's really all I got to say. And for anyone wondering, I'm still making a lot of gaming videos, as much as I can. I've also had to catch up with a bunch of stuff, just real life, get all that sorted. I'm thinking about picking up a new webcam. This one keeps resetting all of my settings every day, and it's driving me nuts. So that might happen. I picked this up for $20 on sale, right as COVID hit. Sarah Boone, nothing new that I've seen in her appeal or anything like that. But yeah, I'm trying to get things done again because I want to get things done by for June so I can focus on the next trial with Lori and cover it every day. So I'm trying to figure all that out. But also, I have to cover this game while it's hot, so everything's getting shoved into a really tight space. So this is 24 hours old, right? This coverage here. That's when it hit the internet. As you can see, it was submitted the 1st of May. I don't know when it got out there. So I do apologize for being late. Other people have probably covered this on YouTube. I'm guaranteeing they have. I just haven't had the time to catch up until now, and I wanted to get this video done while I could. Thank you all for tuning in. I will see you in the next video.